seated. Good morning. Excuse me. Now's the time set for oral argument in our cause number 1CAIC 18-0079, City of Phoenix versus the Industrial Commission of Arizona and Derek E. Henderson, the respondent employee. Excuse me. For everybody's information, these proceedings are being both audio and video recorded. We've also added the feature, as some of you may know, of being live streamed and recorded, so nothing goes unrecorded in this courtroom. And barring any unforeseen problems, you'll be able to critique yourself on YouTube in a couple of weeks. And be available through the live streaming, I'm sure. Counsel, each side is going to be entitled to the traditional 20 minutes. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. And I bet you've heard that before.
No.
However, ultimately, your reserving of rebuttal time will be up to you. We have reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in addressing the court this morning. And counsel, lastly, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel for the appellant, you can begin. I feel the same way, by the way.
I am having the same problem. May it please the court, my name is Todd Lundmark and I represent the petitioners this morning. Like probably everybody else in this room, I clearly recall where I was and what I was doing when family members called me to let me know that my parents had died. It's an experience we all share at some point. It's as inevitable as it is personal. The case before you involves a police officer, but more accurately, it involves a son who happened to be a police officer. Because when he received his phone call from his sister, letting him know there was a problem with their mother, it was sheer happenstance that he happened to be at work at that moment. The mother had been ill. They had reason to be concerned about her. She was not responding to phone calls. She wasn't answering her door. The sister asked Mr. Henderson to head over to see what was wrong with the mother. And as it happened, she lived only a mile away from the station. So he did probably what everybody would have done under the circumstances. He left his workplace to check on his mother. The administrative law judge found this claim to be compensable because while he was en route from his station to his mother's house, he answered a dispatch call by saying he was on his way. This was enough for the judge to conclude that at that moment he was in the course of employment.
Don't we have to defer to that finding?
It's a legal conclusion. There's no question that he responded to that call. The question is whether, on the facts of that case, it was enough to transform a purely personal deviation into a compensable claim. That's ultimately the issue before the court today. Our answer to that is no, and let me give you our reasons for why the answer is no. First of all, I think it's clear that this was a deviation. He was a property crimes detective. He was not a first responder. These were not the kinds of calls that he would routinely respond to.
But he's allowed to respond. There was no rule against it.
That is correct.
And he had a history of responding to these types of calls.
He has. I don't know that that was our record necessarily, but the evidence was clear that if he was on the road someplace, most of his work was done in the office, but if he was on the road someplace and he heard one of these phone calls, it was permissible for him to respond. I think Chief Roberts referred to this as a volunteer. He could have done that. But he was clearly stepping away from his own work as a property crimes detective when he did this. And he was obviously responding to a call involving a family member. And the evidence in the case was the officers aren't asked to respond to calls involving family members. That's not something he would have done. He was clearly, as Lieutenant Leshner said, breaking away from his job at that moment.
Counsel, am I correct in saying that some portion of the testimony in this case indicated that the department, and I don't want to overstate this, but didn't promote the idea of people taking calls in regard to close friends and family members?
I think the evidence was to the effect that it's human nature to respond to an emergency call involving a family member. Nobody's going to fault him for doing what he did. That was the essence of the testimony.
Why would they then have what I guess I would refer to as a policy indicating probably best practices are not that you do that?
Because it respond to the 900 calls, the welfare calls,
Yes.
the wellness calls. That's how they set up their agency. They held the first responders who are primarily responsible for those calls. That's our testimony. Would it have been permissible for him to do that at random? Yes. The question is, was it a normal feature of his employment? Clearly the answer is no. And if you add to that the fact that this was a family member, normally that's not something that the guys would be asked to respond to. That was our evidence.
Why? Why would they not be asked to respond? It seems like they'd be centrally focused on what was going on there. Why would they be asked not to respond?
To a family member? We didn't get in a lot of detail about that. I just assumed the reason was there was too much emotional investment. Let others take care of that type of family emergency. There'd be a lot of conflicts in getting involved in those kinds of things. But that's not something we, in all honesty, was worked out in great detail in this
As a
testimony.
general matter, wouldn't the department want whomever is closest to be the person to respond to these types of calls, whoever can get there quickest?
Absolutely. And that was our testimony. This leads to the other.
Let me back up before you move on, and I'm not trying to distract you too much, just a little bit. You said earlier in response to one of my questions that course of employment is a factual or is a legal matter that we would review de novo. For some reason, I'm not 100% on board with that, so help me get there. Why isn't this a factual finding? Because the ALJ was in a position to review the testimony, see what was permitted, what was not permitted under Phoenix rules, and therefore that is a factual finding. We should defer to that.
I think my best answer is found in the well-established dual-purpose doctrine. This idea that when a trip like this has both personal and work-related motivations, which predominates, and secondarily if Officer Henderson had called off and not gone on to his mom's house, would the city of Phoenix have had to hustle and find somebody else to take his place? Just to break that down, that's the legal question. And here, there's no question that the predominant reason for his trip was to check on his mom. I asked him on cross-examination, had you never heard that dispatch call, would you have gone to your mom's house anyway? And his answer was obviously yes.
But responding to the dispatch call changed his duties. If he was responding there as a son, his actions and reactions might have been very different. He might have had another first responder arrive there shortly thereafter who would have been doing the resuscitation and not him.
Well, that's the second part of the dual purpose doctrine.
Right, that's the arising out of as opposed to a course of. I'm focused just on the first. Was this in the course of his employment?
Yes. So the second part of the dual purpose doctrine is what I think you're getting at, Judge. And that is, let's say Officer Henderson, for whatever reason, had changed his mind en route to his mom's house.
En route to his mom's house.
En route to his mom's house.
Thank you.
Now, we know he called, and the testimony was once he called to say he was en route, he really needed to let them know if he changed his mind. And Chief Roberts said that would have been fine too. What the evidence showed was, from both Henderson's testimony and Chief Roberts, was that as a matter of protocol for these kinds of calls, they have multiple units who are called. There are backups. And in fact, that was Mr. Henderson's testimony. He said that his recollection was, as he was en route, there was already a patrol sergeant and another patrol officer who were rolling, to use the police vernacular. The point is, had he called off, there would not have been a mad scramble to find somebody else to take his place because we already had people going to that house. His testimony was, shortly after he arrived and was working to resuscitate his mother, a patrol sergeant did arrive. And that was Lieutenant Leschner's recollection as well. By the time he got to that scene, another uniformed police officer was already there.
I thought he unlocked the door and let them in.
No. Henderson was the first one there. So he had the key, he let himself in. But as he was en route, the testimony was there were already folks on the way as well, and they also arrived. So the point I'm trying to make is, under the dual purpose doctrine, if he had called off, there would not have been a special need to bring somebody else along because they were already on the way.
So how much of our analysis depends on the nature of the injuries that he suffered? Say, same facts, but before he reached his mother's house, he had a car accident. And he's injured.
I think it's the same analysis. If the predominant purpose for that trip was personal, then the whole trip is not in the course of employment. I think that's the analysis. If the entire trip, if the trip was in the course of employment, and he took care of his mom and was driving back to the station and got in a car accident, under your example, that's compensable.
Well, that's farther away, but I mean,
Yes.
on the
Yeah.
way, your position is, it's, okay.
I think the question is, what was the predominant purpose for that trip? It
So-
was clearly personal.
So then, adding to that analysis, how much does it matter that this was not just any CPR attempt, this was a failed CPR attempt on his mother?
I think it makes all the difference in the world, and that's the third point I wanted to make, and that gets to the arising out of issue, which for some reason seems to have gotten lost in the judge's analysis in this case. When we talk about the compensability of a claim, we're talking about both course of and arising out of, and my judge really focused on the course of factor, and I've given you my best explanation for why this wasn't in the course of employment. But the other thing that always impressed us from the minute we analyzed this file was the fact that it was his mother. When we talk about arising out of, we're talking about the origin of the risk. Was it work-related? Was it personal? Was it mixed? I want to offer to you that the death of a mother is a purely personal risk having nothing to do with the employment. Had this happened when he was off duty, or had he been retired for 5 years when his mother died, the character of this loss as personal to him would remain the same.
But in that regard, how is it different from the situation of a worker who has a bad back, who is asked to lift a heavy bag and does so, and the lifting of the bag exacerbates a pre-existing condition? That's a particular, he is injured because he had the bad back. It wouldn't have injured, the same work task would not have injured another person. How
You
is,
know, and I would call that a mixed risk. So you have both the personal component and the work-related component. The work-related component, of course, is lifting the box in your example. That's not what we have. The mother's death had nothing to do with his employment.
yeah.
How many times had this officer,
But wait, I agree the mother's death had nothing to do with his employment, but that's not what we're here about. It's his psychic injury from experiencing her mother's death, arguably in the course of his employment. So this seems to me, I mean, whether you want to call it a bad back or a fragile psyche, this is exactly Judge Johnson's hypothetical. So I would like you to explain why it's different than the bad back.
Well, the risk does not arise from the employment in any way.
Because,
It's his mother who has the health problem, and the workplace did not in any way create that situation. He responded to it as a
So
son.
he'd responded to a call involving another person who didn't happen to be his mother and felt that he had done something insufficient to resuscitate him and that person had died, it would be compensable?
That's a good question, and that arises in the context of unusual extraordinary stress, that whole argument.
but you're saying he responded to this as a son.
He did.
So he didn't respond as an employee of the police department, I think is the
Not initially.
analysis, right?
Correct.
And he
Correct.
would have gone anyway.
He would have gone anyway. That was as
had he
clear as can
ever
be.
answered, he had answered these kinds of calls before, I assume.
Yes, he had been a patrol officer for 10 years before he became a detective.
So he'd gone to these types of calls where there was help needed. Is that fair?
Yes. Yeah.
Did he ever have this kind of an outcome before?
Not that was in this record.
So he went in, and I take nothing away from the officer himself, okay? It's a tough situation. But he went in there simply as someone who had been trained to do a job before, and did the best job he could, and I'm assuming, just for, I guess, discussion, I'm going to assume that sometimes he was able to resuscitate, and it was very gratifying, and on other times maybe it wasn't, but he didn't go through what he went through in this case.
You know, his testimony was some years earlier he had actually performed CPR successfully on somebody. This was while he was a patrol officer. And his testimony was he contrasted that with his failed attempt to resuscitate his mother, and that was hard on him. That was his testimony. I don't think he went any further than that to say this was something he did as a matter of routine.
I'm going to interrupt you for another second. I apologize for this, but I want to give you an idea where I'm at so you can kind of help me maybe with what I think is the issue that I'm hung up on. I agree with the ALJ on the course of employment. I think once an officer responds to a call, if he wasn't told not to respond, then he's in the course of his duties. I think the ALJ, I agree with you, that the ALJ did not respond to the arising, or did not apply the arising out of analysis. And this, if you kind of look at it as two examples or two extremes, you have the Judge Johnson's extreme of either a good back or a bad back, but you're lifting a 50-pound bag, and it's clearly in the course of your employment and you're injured, that's compensable. You have this same situation, the officer is driving to his mother, and a neighbor who's mad at him because of yard clippings shoots him as he gets at the neighbor's house. That's not compensable because that's a wholly personal. And this seems to be somewhere in between. It was the course of his duties that he was resuscitating, and that's something he's trained and expected to do. But the injury, at least the psychic injury, seems to be focused on his mother's relationship. So why wouldn't our answer be to remand it back to the ALJ to make a fact finding to see what percentage, or I don't want to use percentage, but which preponderates in this case? Is it just he would have been injured if any other woman in a similar situation had been injured, or is this just because it was his mother that he suffered this injury?
Yeah, as I'm listening to your comments, I keep going back to the mental injury statute, which talks about unusual, extraordinary stress. And we look at that as an objective standard. From an objective point of view, was the activity itself unusual rather than the claimant's response to it? My best answer to you, Judge, is his response was very idiosyncratic, and we understand why.
I'm sorry, his response was what?
Idiosyncratic. It was personal to him. It was a subjective response. Officers are doing this all of the time, and the question is, would a reasonable officer in the same situation respond the way he did? And the answer is probably not, although I will agree with you, we didn't get a lot of analysis about that. But I think we can all accept that the reason he responded the way he did was we're talking about his mom.
Does the record tell us whether he would have suffered the same psychic stress had he been performing CPR on someone not his mother and failed?
We don't have that in this record.
Put differently, did his expert tie his particular psychic stress to the fact that he failed to resuscitate his mother?
That was Dr. Vesper, a psychologist, and I don't remember her addressing that in any detail.
Okay.
That's my best answer. I would hope you would rethink your feelings about the course of, for the reasons I gave you. But I have to say again, if you talk about workers' comp analysis as the quantum theory, arising out of and in the course of, and does one clearly outweigh the other, from the very moment we analyzed this case and realized it was a personal call to his mother's house, we thought that arising out of, personal part of this, clearly outweighed any potential work-related connection that could have arisen when he just incidentally responded to that dispatch.
Wouldn't Nolan support the idea that there's a sliding scale sort of, and what Nolan did, it distinguished Sachs, and Nolan said, well, Sachs was the bad back case, or the bad knee case, I believe, on a toilet. And Nolan was the no bad back, but just injured getting up and down from a chair.
Yeah, Sachs was the toilet case. And Nolan was a case, as I recall, that did not involve any sort of mixed risk. There was no predisposition. It was just an actual work-related risk.
Right.
That was the whole
But what
thing.
they found was, they said, well, we can distinguish this case from Sachs on two bases, which is, one is there's, Sachs had a very light connection to the course of employment because everybody has to use the toilet. I don't think that's much of a distinction from Nolan because everybody has to get up and down from a chair while you're at work. But then you also have the the risk analysis on this side too. So even if it is in the course of employment, when it's a weak connection to course of employment, I believe is what the Nolan court said, then the fact that there's personal risk kind of mixed with the work-related risk.
I agree with you.
Controls.
So Sachs was a weak course of because it was a personal comfort activity.
Yeah.
She had a pre-existing condition. There was no evidence of increased risk in that bathroom. The court said there had to be increased risk or we're not going to cover it. And that's still good law. Nolan, I'm trying to remember, I think was the guy who was sitting down on the chair.
Yeah, she just
Oh,
rose and
yes.
something happened to her.
And my clients would want to know why in the world is this compensable? And I tell them it's compensable because you're in the course of employment at the moment this happens. As I recall the facts of Nolan, there was no predisposition for that type of injury, and there was a connection. The doctors connected the mechanical movement of sitting down and chair with the back strain. That was not.
So your argument would be, this is closer to Sachs, where it's, even if there is in the course of employment, it's a weak course of employment because there's a whole lot of personal aspect of it.
I think that's it. Exactly. I agree.
Thank
I
you.
have 57 seconds I'd like to hold on to. Thank you very
Thank you.
much.
Good morning. May it please the court, my name is Christina Reeves, and I represent the claimant, Detective Derek Henderson. Detective Henderson served as a police officer for the city of Phoenix for nearly 25 years. He was injured while discharging his duties as a police officer. The ALJ found that his injury was compensable under Arizona's workers' compensation law. The record supports the ALJ's finding, and we're asking this court to affirm the ALJ's award. And I'd like to start this morning where my friend from Phoenix left off, and that is on the arising out of element. First off, my friend misstated the applicable inquiry for arising out of. He stated that the arising out of inquiry has to do with the origin of the risk. That is only one small part of the arising out of inquiry. The arising out of inquiry actually has to do with the origin of the injury. You focus on the origin of the injury and you look at whether or not there's a causal connection between the injury and the employment. And that is the focus of the arising out of inquiry. And the ALJ correctly found that that inquiry was met here, that the injury arose out of Detective Henderson's employment because he was injured because he was discharging his duties as a police officer.
Is it undisputed that the mental injuries he suffered were caused by the fact that it was his mother that he was trying to resuscitate? In other words, he would not have suffered the same injuries had it been the sort of CPR call that he did back in the day when he was on patrol.
The fact that the victim here was his mother, yes, it's undisputed that it was a significant contribution to his injury. But what the Dr. Vesper testified to was that another significant cause of his injury was the fact that his mother died while he was performing his duties as a police officer.
And that does not move us away from the fact that it was his mother.
It does not, Your
And
Honor.
that the mother was the compelling factor in regard to the injury happening.
The mother was the compelling factor to the injury happening, but the arising out of inquiry doesn't require that the employment be the sole cause of the injury. You can have a personal connection to the injury. As long as there's some work-related contribution to the injury, then it arises out of. And Dr. Vesper testified, and this is on the transcripts May 21st at page 26, that the fact that Henderson was on the job when he was trying to resuscitate his mother and was unsuccessful at it and was doing a job as a police officer contributed to the reaction that he had and the stress that he endured as a result.
Counsel, would it have been possible for Mr. Henderson to not have given his mother resuscitation or attempted to resuscitate her as a police officer?
As a police officer, no. As a son, of course. He would have been a bad son, but as a son, if he was just there as a son and he walked in and saw his mother unresponsive, he could have turned and walked away. And we would say he was a bad son, but we would also say he was a bad police officer.
But weren't there other police officers present that could have done the resuscitation instead of him?
No, not at that time. He was the first on scene, and he began resuscitation, and he was attempting CPR for approximately 5 minutes, according to the record, before additional help arrived.
Does there anything in the record to suggest, and I don't think this is relevant, I'm more curious, anything in the record to suggest that by him responding, it delayed other responders from coming, or is it, as opposing counsel stated, that they were on their way as well?
I would disagree with counsel's assertion that there were other police officers on their way at the time that Detective Henderson arrived at the residence. The testimony was that once he responded to the dispatch call, that that call was answered and that he was the officer that was responding, and the ALJ found that his actions benefited his employer because once he responded to the call, Phoenix did not have to supply another officer to respond to that call. Now, the moment that he broke down the door and saw that his mother was unresponsive, he called for backup at that time, and they arrived 5 minutes later.
Would you agree that the question of whether his injuries satisfy the test of arising out of it in the course of employment, that's a legal question that we review de novo?
Whether or not they, in the course of and arising out of elements are satisfied is a legal question this court has held, and this court does review legal questions de novo.
Is there any fact finding that was done that needs to be redone in your view?
No. The ALJ made sufficient findings of fact to support his conclusions that the injury occurred in the course of and arising out of the employment. The court found in finding of fact 32 that by answering the wellness check call, Detective Henderson was performing a police function, and as such, at the time of the injury, he was performing a police function, and that his actions benefited his employer. And also in finding of fact 32, the ALJ found as a fact that Henderson was performing a police activity at a time, in a place, and in circumstances where he was expected to be during the course of his work when the injury was occurred.
Having answered the call.
Having answered the dispatch call, yes.
In terms of assessing the risk and the injury, depending on which approach you want to take, to determine whether it was arising out of, how do you get around the fact that he was on his way regardless? He was on his way regardless. He would have done what he did regardless.
And I think we look at, and you look at this court's decision in Lane versus IC18. And in that case, there was a police officer, and while he was out with his friends, they were shot at, and him being a trained police officer sought cover, but his friend, not being a trained police officer, basically froze in place. And so he left his position of cover to go and rescue his friend. And when he did so, he was shot and he was injured. And the court found that, and he testified that even if he hadn't been a police officer and had a duty to assist his friend, because it was his friend, he would have helped him anyway. Regardless of whether or not he was a police officer, he would have helped him. And the court said that that is not enough to relieve him, to separate the fact that he was a police officer and he was in the course of his duties and the injury arose out of his duties as a police officer. And I think the same analysis applies here. Even though he had an independent motivation to assist his mother, he also had a professional obligation to assist his mother. And that makes it fall into the arising out of category.
And then how does the idiosyncratic nature of the effect of that CPR experience then factor into the arising out of analysis, in your view?
I don't think the idiosyncratic nature factors into the arising out of inquiry, because it's a contributing factor, and the fact that it's idiosyncratic has nothing to do with whether or not it's contributing. The idiosyncratic factor goes to whether or not it was an extraordinary, unusual, or unexpected stress that caused the mental injury, and that's where you consider the idiosyncratic nature of the injury is in doing that inquiry. And the ALJ did find that is I mean, if he had just been responding to a person that wasn't his mother, it wouldn't have been an extraordinary event. Patrol officers, police officers, first responders respond to calls all the time where people unfortunately end up passing despite their best efforts. That's not an extraordinary event. It was the fact that it was his mother that he was unable to resuscitate that made this an extraordinary event.
Where is the support in the record that the ALJ, you cited finding of fact 32, but as I read that one, it applies to the course of employment. Where's the ALJ's findings that support, or facts that support the notion that the arising out of was met in this standard, in this regard?
The ALJ made findings of fact and then concluded from those findings of fact that the injury occurred in the course of an arising out of, and she didn't, I keep calling her she, he didn't delineate which facts supported the in course of and which facts supported the arising out of. But there are sufficient facts in the record that the ALJ did make to support his legal conclusions that the injury occurred in the course of and arising out of.
Give me your best 2 or 3 that you think show that the ALJ used this fact to support the arising out of.
The fact that, again, that Henderson was performing a police activity at the time that the injury occurred, that he was discharging his duties as a police officer, and that is he was injured because he was discharging his duties as a police officer. That's what supports the arising out of. The fact that that at the time that he was injured, he was discharging his duties as a police officer.
But that would say that any injury suffered while discharging your duties is compensable.
No, it would. It was because, not just that he was discharging his duties, but that he was injured because he was discharging his duties as a police officer.
So if he's driving toward his mother's house and he gets the call, at the time he receives the call and says, I'll take the call, he begins discharging his duties as a police officer, correct?
He officially goes on duty. I mean, a police officer is never 100% off duty, but he clearly goes on duty once he answers that dispatch call.
So then is there a sliding scale, or is there a stair-stepped system as to how much is discharging his duties as a police officer and how much is a concerned son race into his mother's assistance? In the course of this, does the scale slide as he gets closer to his mother's house, or as he gets to the house, is it one standard? When he goes into the house, is it another standard? How does that work?
As in terms of whether or not he's on duty, a sliding scale is in his level of being on duty.
And how we're going to interpret it as discharging his duties?
I don't think there's a sliding scale per se, but I do think that events that occur make it more clear during the course of the event that he was on duty. Once he left his desk, it would be a very difficult argument to make that he was discharging his duties as a police officer. Once he answered the dispatch call, he was discharging his duties as a police officer. Once he responded to an emergency situation, he was also performing his duties as a police officer. And it doesn't make it that he was additionally performing his duties, he was still performing his duties as a police officer.
But when he walked out the door from his office, from that area, at that point in time, he was going to see his mom because of a call from his sister, right?
Yes, Your Honor.
And he was discharging his duties as a police officer and doing that?
No, at the time.
That's my point.
Yes, at the time, once he left his desk, he was not, again, police officers are never 100% off duty, but he was not performing his employer's task once he left his desk. He was performing personal task.
And then he got the call.
Once he got the dispatch call, then he was performing his employer's task.
Is there any point, let's strike that. Go ahead, please.
Yes, Your Honor.
There are some fairly strong, I guess I'd say, intangibles here as far as what we're trying, do you understand what I mean? Trying to interpret how the obligations or the responsibilities or whatever kick in. And it's just, I'd like to get that straight in my mind. Go ahead.
Yes, Your Honor. And Again, we go back to Lane. The police officers always have a duty to respond to an emergency situation. There was testimony that if an officer went into a Circle K to get a snack and a robbery occurred, he would have a duty to try to thwart that robbery safely. If he was driving home and saw a traffic accident where assistance was needed, he would have a duty to stop and render aid. So a police officer always has to respond to emergency situations and render aid. So even if he hadn't gotten that dispatch call, there is an argument that once he responded to the emergency situation of his mom needing aid, that he was discharging his duties as a police officer. That's a more difficult argument, granted, but the fact that he did answer that dispatch call makes it absolutely clear that he was on duty. Once an officer answers a dispatch call, there was testimony, he is on duty until that dispatch call is cleared.
But I was just looking at the Lane case which you cite, and thank you for bringing that to our attention. But the court there said that his employment increased the risk to him in that particular case. And I don't know that we can say that, can we, in our case?
Can we say that, well, it increased the risk? If you look at Lane, I mean, did it really, the fact that he was a police officer, did it really increase the risk that he was getting shot? I mean, all of his friends, he was getting shot at, not because he was a police officer.
No, but he left cover.
But he did leave cover because he was a police officer. So here is the same argument. He rendered aid. The reason he knew how to render aid, the reason he knew how to perform CPR was because of his training as a police officer. The reason he knew how to respond to that emergency situation. Just like in Lane, the police officer knew how to respond to that emergency situation because of his training. Here, Detective Henderson knew how to respond to that emergency situation because of his training. And it was his response that triggered the injury. So you can say that his training and job as a police officer did increase his risk of the injury, because
You can't say that?
No, you can.
Thank you.
At least somewhat, because the ALJ found that it was not just arriving at his mom's house that caused the injury, but it was trying to resuscitate her and being unsuccessful at it. And had he not been a police officer, he may not have been able to try to resuscitate her, and he would not have felt the failure that he felt at not being able to do so when he had done so in the past.
This is where I get hung up, and I tried to ask your other counsel about it. It seems to me that the injury isn't the failure, it's the failure of his mom. So that the risk wasn't from him performing his duties or doing it, but it was that his failure with his mom that caused it. So how is the performing the duties increase the risk? You said earlier, if it hadn't been his mom and he'd failed, we wouldn't be here.
And again, that doesn't go to the rising out of. If it hadn't been, if he had failed and anybody, if he had tried to resuscitate somebody and failed and had suffered an injury because of that, that would still be a rising out of. But it wouldn't satisfy the extraordinary event
Right,
criteria.
but the only reason you satisfy the extraordinary event is because of this wholly personal risk.
Because of his mom, but it's two separate inquiries. The rising out of inquiry is separate from the extraordinary event
That depends on where you
inquiry.
define the injury. I mean, isn't...
Well, the injury is the PTSD. I mean, the event that caused the injury, the ALJ defined it as arriving at his mother's home, finding his mother unresponsive, attempting to resuscitate her, and being unsuccessful at it.
And that is the PTSD that arises from that.
The PTSD does arise from that, and that's what
But the only reason it
Dr. Vesper
arises is
testified to.
because it's his mom.
That was my next question.
The only reason it arises because of his mom, that has to do with the fact that it's an extraordinary, that brings it into the category of being an extraordinary event. If he was claiming a mental injury simply because he responded to a stranger and the stranger had not survived, that would be, and for a police officer, unfortunately, that is not an extraordinary event. But responding to a dispatch call and having your mom die as a result, that is an extraordinary event.
One of the cases I looked at, Judge Johnson can probably remind me of the name of the case, the child porn investigator.
Dunkelbarger,
Talk
Thank
about that
or
case.
however you pronounce that.
That seems to be kind of hurt, or doesn't help you, as I read it. So help me with that one.
I think you can distinguish Dunkelbarger because, like we argue in our brief, in Dunkelbarger, The detective was looking at child pornography, and he found that to be extraordinarily stressful to him personally, because his wife had been the victim of an abuse. So it wasn't the event of looking at the pornography per se that caused the injury. It was his knowledge of his wife's abuse that caused the injury. Here, it was the event. I mean, to draw an analogy, it would have to be if Dungo Barger was claiming injury because he was watching child pornography and he found the victim that was his wife as a child. And that would be an extraordinary event, and that's what caused his injury. That would be a similar circumstance to here.
And you think in that case it would be compensable?
I think in that case, there'd be a very strong argument that it would be compensable, yes.
But the issue there, as I'm remembering, was whether the injury satisfied the particular mental injury statute.
Yes, the question there was not that it rose out of. The question there was whether or not it was an extraordinary, unusual, and unexpected event and stress that caused the injury. If there are no further questions, then I just ask that this court affirm the ALJ's award.
Thank you very
counsel.
much.
Very quickly, in the time I have allotted, we've responded to the reference to the Lane case in our reply brief. I think it's enough to say that once Officer Lane was in the course of his employment, there was no personal contribution to what happened to him. He was in a firefight at that point. He got shot. The comment was made that the ALJ found that what Officer Henderson did benefited the city of Phoenix, and that's an inference. The inference is that nobody else had to respond to the call. Nobody said that, and in fact, that's contrary to the evidence. And I want to cite you to pages 46 and 47 of the transcript involving Officer Henderson's testimony, where he very clearly said, quote, "I want to say that the patrol sergeant for the area was responding along with another patrol officer."
That was
our
the
testimony.
backup?
Yes, they were
Okay.
already, yes, they were on the way.
But that, and I should know this, and maybe I haven't studied the record as close as I should have, but I had originally read it as once he received the call, once he responded to the call, there wasn't someone else on the way. But then once he got there and called for backup, that's when other people came.
No, that was his testimony, that he understood people were already on the way. And then once he tried unsuccessfully to resuscitate his mother, that's when he said he called fire for them to help him with his mom. That was the sequence, according to this record.
So he took the place of the initial first responder.
But he was functioning as a first responder.
But
trying
there
to
was
help his
backup on
mom.
the way.
Yes,
Okay.
yes. And I get back, Judge Jones, to your comment. There is a sliding scale. That's the quantum idea. There's a weighing that needs to go on here. We've got a weak course of, I don't think there is a course of. It's the dual purpose doctrine that comes into effect, and this overwhelming personal component to this case. Thank you very much.
Thank you. We appreciate your time today. We appreciate your expertise in this area, your knowledge. We're going to take the matter under advisement at this time, and we will be issuing a decision in due course. Thank you. We're adjourned.
Nice meeting you.